Hello, everyone. A warm welcome to this special episode of our podcast series accompanying our introductory lecture to public international law. Also, on behalf of my colleague Heike Krieger, I would like to welcome warmly today Professor Tladi, who is with us today. Professor Tladi is based at the University of Pretoria, where he holds a SACHI research chair. SACHI is the South African Research Council, which funds particularly prestigious research chairs among South African universities. Professor Tladi is not just an academic, but is also very much a practitioner of international law in various functions and formats, and in particular, and which is also the reason for having him here today for this podcast, he is a member of the International Law Commission and at the moment also the chairperson of the International Law Commission. Now in today's podcast, we would like to focus on the role that the International Law Commission plays in general in international law, but also specifically on the topic of use cogens, peremptory norms of international law, a topic we have been discussing quite a bit with our students in our regular classes. And Professor Tladi has worked specifically on this topic as the Special Rapporteur of the ILC for a project which has just been concluded and which has looked specifically into the category of peremptory norms of general international law. So a warm welcome to you, Dira. It's wonderful to have you here on the podcast. And without further ado, we should start our conversation then.
Yeah, a warm welcome from me as well. It's good to have you here. And I think, dear, we have reason to celebrate. 21st November is the 75th anniversary of the General Assembly resolution creating or establishing the ILC. And I guess a good start off to get acquainted with the work of the ILC would be to discuss or to hear from you how you think has the ILC developed. Has it changed over time? What were or are its primary purposes, and how has this developed through those, roughly 75 years?
Yeah, no, first of all, thank you very much for having me. I'm really happy to speak to both of you and through you to speak to your students and to spread the gospel of use cogens and the International Law Commission, so to speak. Yeah, I mean, I think the International Law Commission obviously has evolved at the beginning in the 1940s when it started. There was much to do, and I think then it focused a lot more on sort of so what one might call pure codification, and so systematization, and putting into text legal rules that weren't in text. But things change. So one of the things that has changed is that a lot of that has already been done. And so a lot of the sort of core public international law questions have already been addressed by the ILC. So that's one thing that's changed. Another thing that's changed is you've had a proliferation of bodies that do pretty much the same thing as the ILC does. That codify and progressively develop international law. And so with that, the Commission itself has had to evolve. And I think the Commission has done that. The evolution of the Commission, I guess I would describe in the way that I describe in the fifth report in response to some of the comments from states. I say that at least the work on use cogens is what I call codification by interpretation. So where the function of the Commission becomes a lot more putting flesh to the bones, if you like, of law by explaining and interpreting, not just for experts, I think also in part for experts, but not just for experts, but because international law is now becoming a lot more used even by non-international lawyers. And so a lot of the work of the ILC is really also geared towards that market, if you like, the market of non-international lawyers who are called upon to apply the rules of international law. So that's, I think, a major shift. That's not to say that the ILC doesn't do what it used to do, but I think it's now added this in its repertoire. I guess another evolution in the work of the ILC is also the kinds of topics. So whereas in the past, the ILC was a lot more focused on pure public international law, now you see the ILC delving into a lot more fashionable new topics, sea level rise as an example. So yeah, I mean, I think the ILC has evolved in a lot of ways.
When you talk about this turn to codifying interpretation, how's the reaction of states? I mean, I could imagine that states would think you try to restrain them in interpreting international law, which is above all first their business, one could argue. Or do they think it's preferable to having to conclude new treaties?
Well, so I mean, I want to start with it's their business a bit, and then I'll respond to the actual question. I mean, I think, yeah, it is their business, but so is treaty making, right? And so in a sense, the function of the commission is to assist states. And so even when the commission does draft articles, which are pure codification, that's something that can be done by states, that ought to be done by states, where the commission engages in putting together draft articles for the purposes of becoming a treaty. That's more classically the function of states. So in a sense, the commission assists, and I think that's the same with codification by interpretation. The commission is fulfilling its function when it says, we think this is what the law means, and states, of course, are always happy to sort of reject that. So that's just to respond to the part about would states think that we're doing what they're supposed to be doing? Yes, I mean, they're supposed to be doing that, but they're also supposed to be doing the other things that the ILC is classically understood to be doing. What do states think about this turn? I mean, it's hard to say what states think. Because there's a certain group of states that are very vociferous, and so because they say something, it's easy to sort of get a sense that, oh, states are against this, when in fact it's a few states but that are so loud and so powerful. I was at a conference on Friday, a Miami conference, where the US person responsible for the ILC, and so who drafted the comments, said, oh, states said this. And I said to him, I think it's really very arrogant to take comments of 7 states and say states said this. And that's a sense that I get. So yeah, if you I guess the common perception is that states don't like this, and states are complaining, states are saying this is not clear, this turn to draft conclusions in this other way, it's a way to sort of shield them out of their work, in a sense, because we're putting out text as if it's law, and we're not giving states the opportunity to recraft it into treaties. But by and large, other states don't have those concerns. I mean, so there's a particular group of states, and because they're very loud, it seems like that's the view of states. But I don't think that's certainly if you're in a position where I was, where you are tasked with going through all the comments of states, and so you can say there are 7 states that said this, there are 6 states that said this, there are 40 states that commented on the topic and didn't mention this. And so again, the conclusion that I draw from this is those states don't have an issue with it. Then that gives you then that certainly gives you a different picture and a different perspective. And I certainly have a different perspective on that question.
To follow up, oh, sorry, Helmut, if you want to, or maybe I go first because it's a direct follow up. So my follow-up question would be, do you think that the ILC works as an anti-hegemonic instrument in the lawmaking process because it can give room for voices of the not so powerful states?
I would have had the exact same question, by the way.
Yeah, I don't think so. I mean, that's my approach. But you know, I mean, the ILC is a body of 34 members that you know, I mean, they're very, again, the same dynamic that I've just described is also replicated a lot in the ILCs, right? So you've got 4 or 5 or 6 members, you know, who come from big states and they're very influential, and when they speak, it sort of drives. So very often the ILC does in fact reflect the views of the powerful. In some instances, the ILC sort of, you know, in particular instances, for particular reasons, the ILC sort of bucks that trend. And very often there's a backlash. So use cogens is a typical example of that. You know, and the reason is I, as a special rapporteur, have as my philosophy, and by the way, I said this in my capacity as the chair of the ILC when I did my final concluding remarks on last week, Wednesday, I think, Thursday or Wednesday. You know, I said my approach is to give a voice to the voiceless, and to, in a sense, reduce the focus on the, you know, the voice of the more powerful. So I've said this, but that's not always the outcome. With use cogens, I was clear about that as a driver, and in many ways, I mean, the big powerful states are very upset. So on draft conclusion 16 and the mere mention of Article 60, the mere mention of the Security Council, draft conclusion 19, and the audacity of the Commission to suggest that this reflects customary international law, the inclusion of an annex which lists something like the right to self-determination.
Mm-hmm.
You know, how dare they, especially when we have spoken to them, and we've even spoken to them privately, that, you know, if you don't want to be in trouble with us, don't do this. And so I mean, my understanding is that in the General Assembly right now, in fact, in about an hour, there will be consultations on the use cogens resolution. And my understanding is there's a very strong push by some states to sort of do something different than what has been done. So not annex the draft conclusions to the resolution, avoid things that say we welcome it. You know, and I understand that that's in part a response to the fact that these draft conclusions seek to challenge the powerful and sort of the dominance of the powerful.
In a way, probably this project really strikes at the heart of what states conceive themselves to be, and to be the masters of international law. And from this perspective, use cogens from the outset has this dimension that it is potentially curtailing this freedom of states more than just ordinary international law. But I had actually a technical follow-up question too, and maybe it's too technical for the podcast, but I'm asking it nonetheless because you spoke about kind of a couple of states which are very outspoken and powerful, and then a lot of states, a larger group, which hasn't expressed themselves on the issue. And I always found it difficult when researching what the ILC has done and how states have reacted, how to measure this silence of this large group. How can you imply that they are fine with it? Have they not just had the resources to comment on that? Have they not seen that it poses an issue? And so as a PhD candidate, I did this for complicity, for instance, later on for your volume. I tried to do that for the legal consequences of serious breaches. And what is your advice to researchers, to young students who work in the field, how to assess when states don't say something in this regard?
I mean, look, I think there's a lot about it's about context, right? So you're right. There would be instances when one cannot draw any conclusions from silence, but there are instances where, in particular, if you are looking at the written comments, I mean, if you're looking at the written comments, here states are given a year. I mean, states are given a year to comment on a text, and the idea is to be as comprehensive as possible. I mean, I think. Yeah, so I think it says something when a state, comments so provides written comments on 15 draft conclusions, and they don't say anything about the other 7. In particular, when the comments are particularly negative, then that suggests something about what they are thinking about the other ones. It's different with the oral interventions in the 6th committee, because the oral interventions, states don't have the opportunity so much to, or at least don't have the same amount of time to have, or haven't had the same amount of time to have studied the text. And so one can understand that the views are provisional. But when the objective, states provide written comments because they want the commission to change their, the purpose of the written comments is to say, we have seen what you have provided us in your first reading. When you do your second reading, i.e. when you are considering amendments, bear in mind, these are the things that we don't like. It's when you think about the context of why written comments are provided. Written comments are provided to influence the final outcome. So obviously, if there's something you like, you don't want to influence, so there's no need to influence, you're not going to say anything about it. You're going to say things about that you think ought to be changed, right? And so when a state is silent, then particularly with written comments, when a state is silent, I think it's fair to draw those conclusions. Yeah, I think it is fair to draw those conclusions in that instance. So it's about context. So the context here is it's not just that a state was silent. It's that a state took the trouble to make written comments in order to influence the ILC, presumably to either change or keep something. And so their silence means, so whether you change it or keep it, so we have no view. So I think one can at least accept that, even if it's not an endorsement, right? It doesn't have to be an endorsement, but at least an acceptance that's fine, right? I mean, at the worst case scenario with written comments, I think you should be able to say, the state is saying, well, that's fine. We don't have a view on this. So whether you keep it or not, that's okay. I think that's fair.
Have you seen throughout longer ILC projects that states may have changed their minds, that they did so for political purposes or out of the legal discourse? What's your impression in this regard?
Yeah, I mean, I think it's not even just with projects that run for a long time. I've seen it also with cogens, where I mean, I'll give you just an example. The first example that came into my mind was, although I know the reason for this, or at least I know I think I know the reason for this. But the Netherlands changed its views on the text. I mean, after the first report, in fact, even before the first report, when the commission was considering taking up the topic, there were 3 states that were very unhappy about the mere attempt. I mean, it was the United States, France, and the Netherlands. I mean, I couldn't understand why the Netherlands, but the Netherlands. And after the first report, it was those 3 states again, joined this time by Israel. As time went on, I think the Netherlands, I mean, they didn't endorse the project in all of its, but the comments were generally very positive. So that happens. On the question whether or not the work is supported by practice, in particular, I think the views of the Netherlands changed. While they did point to certain things where, not that the work isn't supported by practice, but that the commission missed opportunity to provide practice, which is available and so on. Whereas in the past, the view of the Dutch government was, there is no practice available, so don't do this project. there's a shift. I can think of changes in the position of South Africa, for example, with respect to whether or not to have the annex, the list of norms. So yeah, I mean, states change. Yeah, change their minds.
Maybe Helmut, it would be a good time to turn to the annex and questions related to that.
Yes, indeed, we have kind of three specific questions on the substance of the project, and as you've just mentioned, the annex. Indeed, this is the good moment to bring that in. For our listeners, next to these draft conclusions, there's an annex which features a list of norms which the ILC has identified or had identified previously in its work as being of a peremptory character. And you already briefly mentioned that self-determination is in there and that this has been controversial to a certain extent. But maybe you can also tell us a bit more about the general background. So why did you go for this list, and why did the Commission go eventually to kind of re-narrating what it had previously already identified as use cogens, and why is there still pushback against this list?
Yeah. So I'll start with the last question: why there's a pushback against the list. So there's two main arguments from sort of, actually no, there's three arguments. I mean, no, there's two arguments. So the one argument has to do with the content of the list, and then the other one is methodology. I'll come to the methodology later. The argument concerning the content of the list itself is sort of two different perspectives. The one perspective is that we over-included, right? So we included certain norms that ought not to be included. Here the example is self-determination, and that's a view that's pushed very strongly by Israel, Morocco, and the United States, and one can think of the reasons why.
It's pure coincidence that these states
yes. The other reason, which I'm very sympathetic with, but this is that we under-included, that there were certain norms that ought to have been included that aren't included. Why are we not talking about the prohibition of gender discrimination? Why are we not talking about environmental protection, or at least some aspects of the protection of the environment, or why are we not mentioned piracy? So that was one that's been mentioned, and the answer to both of those questions is the methodological question, which explains why we went for this approach of saying we're just simply going to re-narrate, as you call it, what the ILC has done in the past. And the methodological question is, in this topic, we decided at the very beginning that this was a topic concerning the methodology of use cogens. It was a topic, it didn't concern particular norms of use cogens. And so we weren't going to do a study of the prohibition of use of force. We weren't going to do a study on self-determination. The only way in which we could do the list differently was to do a study of individual norms. I don't think there's any other way that you can do it, right? You have to sort of say this report is a report that's going to focus only on self-determination. And by the way, to do it properly, you would also not just use the norms that have been previously identified, you'd also have to go broader. And so as Matthias Forteau said in 2014, when we were deciding whether or not to do the topic, he said, well, if you're going to do a list, you can either do it in 5 minutes or you can do it in 50 plus years. And that's true. So
you
we
went
decided
for 5 minutes. So.
Yes, we went for the 5 minutes. It was slightly longer than 5 minutes, but it was more or less 5 minutes. So we went for the 5 minutes approach because it was simply impossible to do the other approach, which then meant that you actually had two options: either have this list, the 5 minutes approach, or have nothing at all. And the Commission thought that it was important to have a list. This was one of those issues that I, as Special Rapporteur, actually didn't feel so strongly about. In fact, in the drafting committee, I remember I started off in the drafting committee on second reading. I started off and said, I don't really have a view. So I want to hear what the members of the drafting committee say, and then I'll decide on the basis purely of numbers. And the majority of members said, no, let's go with the list. And I guess the view was, if we think back to why we said we wanted to do this topic, to speak to those who might not be experts in international law, but yet who are called upon. It's good for them to sort of have examples. I mean, you, Heike, or so Helmut, if you want the examples, you know where to find them, right? So you can just go to the articles on state responsibility, commentary, paragraph, so and so and so and so and so on. But a judge that's sitting in Pretoria doesn't know that, so it's good. That's why, in the end, the commission thought that we should have the list. And once we decided to have the list, the methodological constraint that we're going to do the 5-minute rather than 50-minute approach meant that we couldn't be creative. We couldn't add more and so on. And also we had to be careful with how we formulated the norms, right? So we formulated the norms largely based on how they were formulated in the articles on state responsibility, so more or less. So that's more or less, I mean, I'm not sure. I think there were a few questions that you asked, and I think somewhere in there's answers to all the questions.
No, very, very much. I mean, we have two other specific questions on the project, and maybe Heike, do you think we should first turn to the use of force question? Maybe that's the better order now.
Yeah, I think so, because it would really follow up on your list. In the list, you have included the prohibition of aggression, not the prohibition on the use of force. In many textbooks on international law, you will find the prohibition on the use of force is being included into a list of used cogens norms. And if you do that, there is a follow-up question with which we have dealt in class, and our students wondered about it. If we assume the use of force is a used cogens prohibition, then how can it be that there are exceptions to that rule, and how can it be that such exceptions are interpreted often in a quite broad way? How do you approach this issue?
Yeah. So of course this is me. This is not the commission, because the commission didn't delve into. Well, I mean, the commission at least addressed one part of your question, and that's aggression versus use of force. On that, really, so again, the commission decided that it was going to use what was in the articles on state responsibility as it's the more common formulation. And of course, there is a difference between, I mean, there's technically a difference between aggression and the use of force. But the only thing I'll say is that if you're going to be technical, then one can say, well, the inclusion of aggression doesn't exclude the use of force, right? So the fact that aggression, of course, aggression is an example, and that doesn't mean that the broader prohibition is not an example. Though I do think that for the commission, not just in this context, but also in the articles on state responsibility, the commission meant with aggression the broader prohibition. And it's not that the commission didn't know that there's a distinction, but just that as a terminological point. The real question that you're asking, though, is about the self-defense. So self-defense, and also the use of force on the basis of authorization under the collective security mechanism, that in a sense circumscribes or describes the prohibition that constitutes the use of force. In fact, perhaps the most appropriate description of the prohibition is how the ILC described it in 1966 as the law of the charter, right? So the prohibition is the law of the charter, whatever it is. So if you're interested in what is prohibited, you must look at the law of the charter, which is Article 2.4, Article 51, and Article 42. So that's what's prohibited. That is the rule from which no derogation is prohibited. Sorry, that is the rule from which no derogation is permitted. And so in that sense, if you're looking at it in that way, there ought not to be any difficulties with exceptions. In fact, derogations, rather exceptions, aren't necessarily derogation, right? So derogation is very different from exception. So that's at least how I understand, how I see the relationship between the prohibition, which is the Article 2.4, and the exceptions. In terms of the expansive interpretations, I've written a lot on the expansive interpretations, and so one, I don't think that the expansive interpretations are consistent with law in general. For the expansive interpretations to come to form part of this law of the Charter on the prohibition of the use of force, they would need to meet not only the normal threshold of customary international law or subsequent practice, they would also need to meet the higher threshold of peremptoriness, and I don't think they do. But actually, I don't even think you get to that. I think personally that these expansive interpretations do not even meet the standard for evolution of law, generally speaking. So whether it's customary international law or subsequent practice, and when I've written on the subject, I have not had to rely even on the use cogens argument. I've just simply relied on the customary international law and the subsequent practice arguments to say there simply hasn't been this expansion that some authors speak about.
I would tend to agree. I have a follow-up question on the first part of your answer, and I was just wondering whether this use of force aggression complex might not even be a good illustration that the effects of use cogens might also diverge to a certain extent, because if we look at the core function that use cogens has traditionally under the Vienna Convention, I think it makes absolute sense to say from the outset you can't conclude a treaty by which you derogate from the prohibition of the use of force. But the additional consequences that serious breaches of peremptory norms trigger, like aggression is a serious breach of a broader peremptory norm, the prohibition of the use of force, this might not be needed if you just have a mere violation of the use of force, which does not meet the threshold of either an armed attack or does not rise to the level of the threshold of aggression, because there, if it's more than just a mere frontier incident, but not an armed attack, maybe an obligation of cooperation or non-recognition, non-assistance difference, but then you don't get into the situation where you need all the additional legal consequences that third states face in the case of a serious breach.
Yeah, I mean, I think that's I haven't thought about it, so Helmut, and I don't want to tie myself, but it sounds reasonable. The only thing I will say is there was quite a lengthy debate, as you know, of course, because it's something that you cover in your chapter in my book, on the word serious and whether or not that ought to be included in or not, and in fact whether the consequences, those consequences that you speak of, shouldn't in any event attach to all breaches of use cogens. That was also hotly debated on second reading, and I think and in fact I think, Helmut, if my memory serves me correctly, I think the reason why we ended up keeping serious is precisely because of what you say, and so the consequence of that, if you look at draft conclusion 19 again, you'll see that there's an additional paragraph, and I think the additional paragraph was to I think it's paragraph 4 now, I can't remember, was to identify precisely that there may be other consequences that attach to breaches of use cogens that are not serious in the way that we've defined them. So yeah, I mean, I think I would tend to agree with that.
Maybe to continue along these lines, these consequences for serious breaches of use cogens norms are a particularly relevant part, I think, of the work of the ILC, as it also kind of connects this project on use cogens with the previous project on the law of state responsibility. And my impression was that in this field, eventually the Commission now more or less confirms what it arrived at in 2001, with some changes in the emphasis what is recognized as a norm of customary international law. Maybe a question more for you personally than as the chairperson of the ILC. Do you see changes now, also further changes as a reaction to Russia's war of aggression against Ukraine, that the ways third states react to this breach might further consolidate this part of the regime of the law, or do you think that the picture is rather unclear and still a bit mixed?
Yeah, I mean, I think so. Two things. One is, I think the war in Ukraine has, in the context of draft conclusion 19, has helped to give concrete examples to what is meant by cooperation and how cooperation can take place. So that's the one part of the question. Sorry, the one part of the answer to your question. At the same time, one has to be cautious about suggesting that all the responses are an accurate giving effect to the consequences identified. Consequences in draft conclusion 19, as is the case in the articles on as in the case of the articles on state responsibility, do not have the effect of giving to legality to conduct which would otherwise be illegal, right? And so they're not a ground for justification for acts. They call upon states to do what they are permitted to do under international law. And so, for example, if and so assuming, for example, that the measures that the cooperative measures that are sought to be taken are, for example, the use of force. Those measures could only be taken, one, in the context of self-defense, and of course that's or two, they could be taken in the context of collective security measures. I make this point because there has certainly been in some quarters the suggestion that we have seen, and by the way, the commentary, or at least the commentaries, and I guess I'm in part responsible for this because I provided some of those examples, include examples of unilateral sanctions adopted. But that doesn't say anything about the legality of those unilateral sanctions. They may or may not be legal, right? They would be illegal if their legality, in other words, does not depend on draft conclusion 19. Draft conclusion 19 is not what gives them legality. Draft conclusion 19 says you should do, or you must do, you shall do what you are entitled to do under international law to cooperate. So that's the only caveat that I would put to that. In a sense, what we see with the responses of states to Russian action is concrete examples of what is possible. I mean, I think one really good example of this is suspension from international from organs of international organizations. And of course, it's not the first time that that's happened. It happened in the 1970s with the suspension of South Africa from the GA, and so yeah. I mean, I think it's the responses are proving to be an example, and in a sense, they've also, although again here one should be careful. I was about to say they also provide further justification for why draft conclusion 19 is now customary international law. The danger with that argument, of course, I mean, there's two dangers with that argument. Oops, I'm losing battery. So there's two dangers with that argument. I mean, one danger with that argument is it would suggest that when we first drafted this, which was in 2019, then wasn't customary international law. The other danger, of course, is that there are many instances of breaches when I mean, I think you mentioned it in your chapter, when states haven't reacted in the way that they ought to react, at least to be consistent with the obligations that are provided therein.
Kira, maybe this is a good point to turn to a final question and go back to the working methods. You have already described to us how the ILC works, how you conceive of the draft reports, how states respond to it, and we wonder, what do you think of these working methods? Are they still the appropriate way of dealing with codification of international law or progressive development, or do you think there is a need for reform within the ILC? Should working methods change? Should there be a different approach? That would be nice to hear.
Yeah, I mean, I have views on working. I think in general, I think the ILC works, and I think that the ILC should, at least in terms of the methodology of its work, but if I were to make any recommendations to a future commission on working methods, one is, I think we spend way too much time on reading statements. I think we could share our views really quickly and then have debates. I mean, real debates about the substance of the work, more interactive approach. Spend more time in the drafting committees. Both for text but also for the commentaries. So that's one. I mean, that has to do with really just sort of cutting out the time for statements. If we want to know our legal positions, I think we can sort of exchange that by email. I think we can, and we can read each other's statements, and then we can go to the text. So that's one point. A second point is, and this is something that was so the commission works in a really strange way. A special rapporteur produces a first report. Their first report is 3 draft articles, and the commission adopts those 3 draft articles. Next year, another report, another 3 draft articles. I find that a strange way of working because there's always a possibility of inconsistency between, and then the ILC has to go back, at the end when it does a first reading. But the ILC never really looks at its work on first reading. I mean, it basically accepts it with, the better way of working, I think, is what the first special rapporteur on immunities wanted to do. If you remember correctly, he had 3 reports and not a single draft article. And I mean, in conversations with him, his plan was to do all the reports, have all the debates, and then know more or less where the members of the commission stood, where he stood, and what his reports told him. And on the basis of all of that body of work, produce a text, and then you go to the drafting committee and you work on the text. Cogens did something in the middle, where the texts were proposed piecemeal, but they were dealt with in the drafting committee, at once. And I think that's, I think the better way to do it would be, sort of the way Kolotkin would have wanted to do it. I think that's I think an important proposal. Otherwise, I think the commission works. I would,
Well, thank you, Lehre. That was a great talk, and I could go on for another hour.
Yeah.
I fear we have to think of the people viewing the podcast. And I guess we're nearly at 1 hour. That is a great talk about international law. We had a great insight into your work, into your expertise in international law, how this thing really works. I think one could really get a feeling about what is the day-to-day business of international law in places such as the ILC, and that was really a great experience, at least for the two of us, and I hope for...
Yeah, we have already learned a lot in this meeting, and so we are optimistic that our students will also be able to learn.
I hope so too.
From
I hope so too. Again, thank you very much for having me.
No, thank you, Dire, for
Thank you.
giving us your time.